Hello guys and welcome back to another video in this series of legal maxims. In this video we are going to look into the maxim of Audi Alteram Patrem. I have mentioned timestamps in the comment section as well as in the description so you all can navigate to the topic of interest. For now, firstly let's look into the meaning of Audi Alteram Patrem. Now, means hearing the other side too. This rule is also called as the rule of fair hearing. Now there is no particular branch as to where this rule is applicable, as its scope is very wide. Okay, now whenever a hearing is done, okay, whenever a particular crime is committed, okay, and a hearing is done, it should be make sure that both the parties are heard. Okay, even if the party who is in the defendant's side is given a chance to be heard and to present its case. This maxim is important as it is a part of one of the three main rules of the natural justice, that is the rule against bias, rule of fair hearing, that is the Audi Alteram Patrem, and the reasoned decision. Therefore, the main aim of this maxim is that no one should be condemned unheard. Therefore, any person, okay, whether he is guilty, not guilty, is none of our business, but he should be given an opportunity to be heard in the court of law. Therefore, any allegation made against any such person has a right to represent himself or appoint a representation for himself to make sure that he has been given a reasonable opportunity to defend himself. A conclusion or a decision without hearing the other side violates the rules of natural justice as well as the principle of fair hearing. This particular maxim was developed so that the people could defend themselves and have a chance, and this rule of fair hearing maxim helps them to execute and achieve this goal. Hence, no justice can be done without this rule of fair hearing, as for a judgment to be fair in nature, it must be made sure that the both sides are heard. Now next, let's look into few components of fair hearing. Now the first component of fair hearing is a notice. It is very important that a person is given a notice or a warning notice so that a person is ready when a legal action is filed. Even so, a show cause notice can be also given where a person is given an opportunity to be heard or to be given an opportunity before a case is taken to the court. Next component of a fair hearing is the legal representation. It is very important in the Indian courts that a person has a legal representation, that is a lawyer. Now this lawyer can be either hired by the person himself or it is provided by the court through legal aid. It is also a part of our constitution to be being provided with a free legal aid whenever a person cannot afford to have a legal aid. Next component of the fair hearing is to provide own evidences. If a person wants in any stage of the court hearing, can provide evidences to support his case. Furthermore, another component of rule of fair hearing is that of cross-examination, as it is the right of the lawyer to cross-examine the other opponent. And the final component of the rule of fair hearing is to have a lawyer of his own choice. Now it is made sure that whenever a lawyer is provided or when a person himself, okay, wants a particular lawyer, he has a right to choose any lawyer he wants. Now let's look into various judgments supporting this maxim. After this, we are going to look into exceptions to this rule as well as look into few judgments supporting these exceptions. Now firstly, let's look into a very important English case of Richard versus Baldwin. Now in this case, the applicant Mr. Richard became Chief Constable of the County of Brighton in 1956. After serving for almost 33 years at the meeting of the Watch Committee, the police authority, okay, on March 7, 1958, it was resolved that he should be dismissed. Okay, but Richard said that he had received no notice on the grounds on which the committee proposed to act, and no opportunity to be heard was given to his own defense. Therefore, Section 191, Clause 4 of Municipal Corporation Act had conferred a power to dismiss any constable who has been negligent of his duty. Richard goes to the court of law because he was thrown out of his job without being represented. The court set aside the watch committee's decision, and thus this maxim was applied, wherein the result was given an opportunity to be heard. Now let's look into another case of State of UP versus Vijay Kumar. In this case, the court held that the principle of natural justice must be read in provision of law by the Supreme Court. That is, whether the law tells to hear or not, but it has to give a notice. Let's look into another case of HPCL versus HL. Supreme Court again clarified that even if the authority has a statutory power to take action, the authority cannot take an action without hearing it, as it would be arbitrary. Now that we have finished with some of the judgment with regards to the Audi Alteram Patrem, let's now look into the exception to this rule. Now the first exception to this rule is impracticability. Now to understand this exception, let's look into the case of Radhakrishnan versus Osmania University. Now in this case, there was a charge of mass copying in the MBA university, and the university cancelled and reconducted the exam. The student went to the court. According to them, their honesty and sincerity as a student has been violated. According to the court, the decision taken by the university was very practical in nature, and this is for the betterment of the education in the society. Now next, let's look into another exception to the legal maxim of Audi Alteram Patrem, that is emergency. It is a ground when the state cannot hear the party. The third exception to the rule of maxim is government decision. Now to understand this, let's look into the case of BAL Company, Bharat Aluminium Co versus Union of India. Now in this case, the validity of the decision of the Union of India to disinvest and transfer the 51 shares of Bharat Aluminium Company Limited is the primary issue in this case. BAL Co was incorporated in 1965 as a government company of India, undertaking under the Companies Act of 1956. Prior to this investment, it had paid up share capital of 488.85 crores, which was owned and controlled by the Government of India. Suddenly, Government of India decided to disinvest in the BAL Co. The court argued the governmental policy decision cannot be taken into court of law. Governmental policy decision is an exception to Audi Alteram, therefore complying by the rule of natural justice. Next, if we look into another case of violation of right, that is Andhra Steel Company versus Andhra State Electrical Board. Andhra State Electrical Board gave concession to Andhra Steel Company. After some years, they stopped giving concession to the steel company. Steel company approached the court. The court decided that all this time till the concession was given was stopped. They enjoyed the concession and therefore their right has been not violated in any manner. Now that's all for today's video, guys. I'll see you in another video. Thank you very much.